Welcome to the Illegal Art Podcast. I'm your host, Michael McCullough. I hear people say all the time that if you own an artwork in New York that might be stolen, then you are safe because the original owner has to prove it is stolen in order to get it back. That is wrong. New York law does not require a putative owner to prove the artwork is stolen. Last year in 2023, there was a great court decision discussing this very issue. The name of the case was Republic of Turkey against Christie's. There, the Republic of Turkey sued Christie's and its consignor Michael Steinhardt in federal district court in New York over the ownership of an Anatolian marble female idol known as the Stargazer. Let me share my screen and show you an image of the work. The idol stands 9 inches high and is one of the finest and largest preserved Anatolian marble female idols of the Kalia type. There are only about 15 nearly complete idols of this type that have ever been discovered, although the fragmentary examples, particular heads, abound. Most of the complete examples have been broken across the neck, as is with this figure, suggesting that the sculptures were ritually killed at the time of their burial. And Turkey brought the lawsuit because it believes the object was stolen from Turkey and should be returned. Turkey said it owns the idol pursuant to its patrimony law because the idol was unlawfully excavated and smuggled out of Turkey. Let's take a look at the provenance and exhibition history of the piece. So in 1961, J.J. Kledgman, an art dealer, sold the idol to Alistair and Edith Martin. And the Martins incorporated the idol into their renowned Gwenall collection for 22 years before transferring it to the Buttercup Beta Corporation, an entity owned by Alistair Martin's son. So the object was still in the family, but was owned by a corporation. The Martins loaned the idol to the Metropolitan Museum of Art from 1968 to 1993, where it was displayed publicly in the Met's permit galleries. The idol was also featured in publications. So between 1964 and 1990, the Stargazer was referenced in at least 7 source publications. In 1993, the Buttercup Beta Corporation sold the Stargazer to Marin Gallery, which in turn sold the idol to Michael Steinhardt in the same year. Steinhardt similarly loaned the Stargazer to the Met, where it was exhibited from 1999 to 2007. In 2017, Steinhardt sold the idol at Christie's for $12.7 million, but the buyer never took possession of the artifact because Turkey made a claim for the idol shortly thereafter. The federal district court in New York determined that Turkey's claim for the object's return, referred to as a replevin and conversion action, failed, and entered a declaratory judgment that all right, title, interest in the idol vested in the owner, Michael Steinhardt. So the district court determined that Michael Steinhardt was the owner. In addition, the district court held that the defendants were entitled to a judgment because they established the equitable defense of laches, meaning undue delay. So there was also a determination by the district court that Steinhardt had a delay defense, meaning that the Turkey took too long to bring its claim, and that it was barred from making a recovery. Now, Turkey appealed the district court's decision, and on appeal, the Second Circuit Court of Appeals looked at the first question of whether Turkey owned the idol and whether it was stolen. So the first issue was, what is Turkey's burden of proof in a conversion and replevin claim? In other words, how much evidence of the theft does the putative owner need to prove in order to be successful in getting their object back? The Second Circuit said the burden of proof is on the defendant of a stolen artwork to prove it's not stolen. And that rule comes from an old court case from 1990 called Guggenheim against Lubell. However, the plaintiff, in their burden of proof, is at least required to make a threshold showing that they have an arguable claim. So that's a quote from the decision, a threshold showing that they have an arguable claim to the property before the burden of proof shifts to the defendant to show it's not stolen. So while the defendant always has to prove they're the rightful owner, the plaintiff still has to make a showing that they have an arguable claim to the property. Now, in this case, Turkey said it did make a threshold showing of theft because it presented three things. Number one, the Stargazer was made in ancient times within the borders of modern-day Turkey. Two, the original seller of the Stargazer was a notable antiquities trafficker. And three, looted antiquities typically appear on the market shortly after their theft, and there is no record of the Stargazer's provenance before its sale to the Martins in New York in 1960s. Turkey says these facts constitute, at the very least, a threshold showing that the Stargazer was found in Turkey after 1906, which is the year in which all of the objects found in the ground in Turkey were owned by the Turkish government. And therefore, Turkey argues the burden shifted to Christie's and Steinhardt to prove by a preponderance of the evidence that the Stargazer was not stolen. So Turkey said they made a threshold showing of theft. Steinhardt should have to prove that the work is not stolen. Now, the Second Circuit said that it has not in the past defined what a threshold showing of an arguable claim of ownership is. But the court said that the district court was wrong in saying that Turkey had to prove by a preponderance of evidence that the object was stolen. The Second Circuit reiterated that the claimant, meaning the plaintiff, must only make a threshold showing of an arguable claim to the pilfered artwork before the possessor or the defendant here must prove the artwork is not stolen. Good for Turkey. But they did not win the case because the second issue was Steinhardt's defense of laches, or the delay, where the district court did decide that Steinhardt's laches defense barred Turkey's claim of ownership. So on this question, the Second Circuit decided that even if Turkey had established its claim of ownership, that they made a threshold showing of an arguable claim, the court would rule that the doctrine of laches bars Turkey's claim over the idol. So to prevail on a laches defense, a defendant has to establish three things. Number one, that the plaintiff knew of the defendant's misconduct. So in this case, that the plaintiff knew the whereabouts of the stolen object in somebody else's possession. Number two, the plaintiff inexcusably delayed in taking action. So in this case, that Turkey took too long to make their claim. And three, that the defendant was prejudiced by the delay. So in this case, that Steinhardt was prejudiced by this delay. The first of these three elements, the court said, may be established where the plaintiff should have known of the whereabouts of the object. So let's take a look at the first and second elements. The district court found that academics with connections to the Turkish Ministry of Culture were discussing the Stargazer in the early 1990s. And this awareness should have put Turkey on notice as to its potential claim, at least enough to further inquire about the object's origin. By failing to investigate, the district court concluded that Turkey's delay became unreasonable. And the Second Circuit said that though the doctrine of laches contains a knowledge requirement, the plaintiffs need not be aware, so Turkey, in this case, need not be aware of the specific circumstances giving rise to their claim. Here, Turkey was privy to enough information that it should have known of its claim to the Stargazer. Throughout the 1990s, the Ministry of Culture of Turkey itself published essays and presentations discussing the Stargazer and its Turkish roots. As a result, the court said Turkey should have been aware of its potential claim in the 1990s. Now, likewise, the Second Circuit found that the district court did not properly add an investigation element to the doctrine of laches. Instead, the district court simply concluded that considering the information available to Turkey, its failure to assert or even investigate its claim to the Stargazer for over 25 years was unreasonable. This, according to the Second Circuit, was not an abuse of discretion and was proper. On the second element, whether there was a delay, the court said Turkey sat on its hands despite signals from its own Ministry of Culture that the Stargazer was on display at the Met for over 25 years in New York City. Turkey's failure to bring a claim until 2017 was unreasonable. On the third element, the prejudice element, the district court found that the deaths of the Martins, who were the original owners in the US, Kledgman, the deal who sold the piece to them, deprived Steinhardt of key witnesses, and this was prejudice to Steinhardt's defense. The Second Circuit said that if the defendants have been held to their burden of proving that the Stargazer was not stolen, they could not have produced a witness to testify as to where, when, and how Kledgman came into possession of the Stargazer. Testimony potentially absolving Steinhardt from liability. That this testimony remains unknown demonstrates why Turkey's delay was prejudicial. Now, the Second Circuit also said that the application of laches also requires a fact-intensive inquiry into the reasonable diligence of both parties. So the defense of laches requires that the defendant was diligent, but also requires, because there's a delay element, that the plaintiff was diligent in bringing their claim. Now, in the district court, Turkey said the defendant's laches defense, rebutted the defendant's laches defense by insisting that even though Steinhardt is a good faith purchaser, the court should conclude that his purported lack of diligence weighs against the finding of laches. Turkey predicated this argument on the contention that Steinhardt was presented with sufficient red flags as to the idol's provenance that he had acquired a duty to inquire or investigate prior to completing the purchase. So if we go back to the provenance history of the object, we will see that when Kledgman sold the work to the Martins in 1961, there was no prior history to the piece. And even though it was on loan at the Met from 1968 to 1993, Turkey was saying that in 1993, Mr. Steinhardt should have asked for more questions, should have asked why the object had no history prior to 1961. Now, on this point, the district court disagreed with Turkey and was unpersuaded, concluding instead that the relevant evidence in record shows that Steinhardt was in fact diligent in the lead up to the 1993 purchase of the idol. On appeal, Turkey disagreed with this finding. Turkey argued that the district court should have held Steinhardt to a level of diligence typically reserved to art dealers or museums or other commercial actors on the New York UCC, and argued that by failing to contact the Republic of Turkey at the time of the purchase, Steinhardt exhibited indifference as to the provenance of the Stargazer. Now, the Second Circuit said that Turkey misconstrues the district court's rationale. After concluding that Steinhardt, as an ordinary purchaser of art, was under no duty to investigate the provenance of the Stargazer, the district court determined that nonetheless, Mr. Steinhardt did investigate the idol's provenance. Mr. Steinhardt had questioned the Marion Gallery about the Stargazer when he bought it. He reviewed a report on the idol that was authored by a noted art expert. He met with other experts and relied on the Metropolitan Museum's good reputation in exhibiting the object. The Second Circuit said that the district court had determined that these efforts were reasonable diligence for an ordinary buyer. The Second Circuit also said, after contrasting Mr. Steinhardt's investigation into the Stargazer's provenance with Turkey's failure to act for over 25 years, quote, "We do not find that the district court abused its discretion in balancing the parties' respective diligence." What that means is that the Second Circuit found that the district court's decision that Mr. Steinhardt had made an effort to investigate the object and did sufficient work to investigate it should weigh more in his defense than Turkey's delay in bringing the claim, which was not excusable. So in conclusion, the court said, quote, equity favors the vigilant. But in this case, because Turkey has slept on its rights, we affirm the judgment of the district court. This is a great court decision because it really clarifies New York law. New York law does not require a putative owner to prove the artwork was stolen. The owner just has to make a showing that they are the owner. The burden of proof then shifts to the defendant to prove that the object is not stolen. And the only thing that will save the defendant is if there was a delay in the plaintiff bringing the claim. Thanks for listening.